Let's start with question number 61. So in this, what is the question is practical question 61. Amar Textiles Limited is a company engaged in manufacture of fabrics. The company has investments in shares of other bodies corporate, including shares in Amar Cotton Company Limited, and it has also advanced loans to other body corporate. The aggregate of all the investments made and loan granted by Amar Textiles Limited exceeds 60% of its paid up share capital, free reserves and security premium, and exceeds 100% of its free reserves and securities premium account. In course of its business requirements, Amar Textiles Limited has obtained a term loan from Industrial Development Bank of India, and the same is still subsisting. Now the company wants to increase its holding from 70% to 80% of the equity share capital in Amar Cotton Company Limited by purchase of additional 10% shares from other existing shareholders. State the legal requirements to be complied with by Amar Textile Limited under the provision of the Companies Act. In the given case, the aggregate amount of all the investments, okay, thus the proposed investment in equity should be made only after passing a special resolution. As per section 186, where investment is made by holding company in its wholly owned subsidiary, special resolution is not to be passed. But in the given case, Amar Cotton Company Limited is not a wholly owned subsidiary of Amar Textiles. Hence, the relaxation of passing special resolution won't be available here. Applying the provisions of section 186 with the prescribed rules, Amar Textiles Limited can make the proposed investment in the equity share capital of Amar Company Limited after complying with the below mentioned legal requirements. Legal requirements consequence here, unanimous board resolution should be passed at a board meeting approving the proposed investment. Approval of members should be obtained by passing a special resolution. No prior approval is required from IDBI as it is not a public financial bank. No default is subsisting with regards to repayment of public deposits or interest thereon. If any such default is subsisting, then it should be first made good and only then the company can make the proposed investment. The company shall enter the prescribed particulars in the register maintained as per section 186 subsection 9 within 7 days of making the investment. The company shall disclose to its members the financial statement, the full particulars of the investment made. If Amar Textiles has made a default in repayment of matured public deposits, then it will not be able to make the proposed investment without the default being made good first. એટલે પહેલા default good કરવું પડશે. Now, practical question 62 comes here. What is it? Mr. Mrs. Anjana is a director of Unique Limited, a professionally managed profit-making dividend-paying company. The said company is having sufficient liquid funds and is remaining idle as of now. With a view to deploy the idle funds, the company proposes to provide either loans or invest in the shares of other companies or both. Considering this, the board of directors delegates the power to the managing director to invest up to 15% of the paid up share capital without passing a special resolution. In the light of the Companies Act, analyze whether the action of the board is relevant. As per section 179 subsection 3 specifies that certain powers are to be exercised by the board by means of a resolution passed at a board meeting only. It interlike includes power to grant loans or give guarantees or provide security in respect of loans and power to invest the funds of the company. However, the board may delegate interlike. Section 186 requires that for advancing loan or making intercorporate investment by a company, a prior approval of the board of directors should be obtained by passing a resolution at a board meeting, and the resolution should be passed with the consent of all the directors present at the meeting. That is, a unanimous resolution is required. Thus, Section 179 allows boards to delegate the above said powers, while Section 186 requires that a unanimous board resolution is to be passed each time for all such transactions. Thus, there is a contradiction between the two provisions. Whenever there is a clash between two provisions, a harmonious interpretation should be done such that both the provisions remains effective, that is, without making any provision redundant. So, the harmonious interpretation of both these provisions would be that a unanimous board resolution is to be passed for delegating the power to grant loans or give guarantees or provide security in respect of loans and the power to invest the funds of the company to the managing director. In the given case, the board has delegated the power to invest only up to 15% of its paid up share capital, which is below the limit given in section 186 subsection 2, and so no special resolution is needed. Thus, allowing the managing director to exercise the power without passing special resolution is also valid. Thus, in the given case, the action of the board is correct, provided that the board resolution passed to delegate the above said power is a unanimous resolution. Note, there is a difference of opinion between the answer given here and the suggested answer given by the Board of Studies. I say, as per the suggested answer, since the unanimous board resolution is to be passed as per section 186 for each such transaction, delegation of said power to the managing director cannot be done. The author disagrees with the suggested answer of BOS, I say, because such an interpretation will make the provisions of allowing delegation to managing director as given in section 179 redundant. This is against the rules of interpretation of law. Practical question 63. Star Limited proposes to acquire 15% equity shares of Gain Investments P Limited for 45 lakhs, which has a face value of rupees 35 lakhs. Star Limited has an outstanding loan of rupees 15 lakhs to a public financial institution and had not defaulted in the repayment of installments stipulated in the loan agreements. Based on the following financial data, advised are limited about the legal position regarding the allowability proposed investment under the provisions of the Companies Act. Authorized capital 1, paid up share capital 0.5, 0.50 crores, free reserves 0.20 crores, so gain investment mark kilo kilo. As no gate proportion, Star Limited does not hold any shares of the company. Star Limited proposes to make an intercorporate investment, and hence it has to comply with all the legal requirements of Section 186. As per Section 186, subsection 2, a special resolution or SR is to be passed if the aggregate of loans or guarantee security or investment so provided along with the proposed to exceeds the higher of 60% of the paid up share capital free reserves and securities premium, that is 60% of 70 lakhs equals to 40 paid up capital free reserves and securities premium. Paid up share capital 45 lakhs. Paid up share capital free reserves. Free reserves. Free reserves 0.20 crores मतलब 20 लाख होगा. So paid up share capital plus 70. So 60% of 70 lakhs is equal to 42 lakhs, or 100% of free reserves and security premium, that is 20 lakhs. Higher of the two limits, that is 42 lakhs. But Star Limited proposes to make investment of rupees 45 lakh, and hence special resolution shall be necessary as it exceeds the limit of rupees 42 lakhs. Thus, the proposed investment by Star Limited is allowable, but the following legal requirements have to be fulfilled. A unanimous board resolution should be passed at a board meeting approving the statements. Then approval of members should be obtained by passing a special resolution. Approval of member should be obtained by special resolution. Then the special resolution passed must specify the total amount up to which the directors are authorized to make loans, guarantees, security or investment. Prior approval of public financial institution from which loan has been obtained shall be required, since the limit under Section 186 subsection 2 is being exceeded, although there is no default in payment. No default is subsisting with regards to repayment of public deposits or interest thereon. If any such default is subsisting, then it should be first made good, and then only the company can make the proposed investment. The company shall enter the prescribed particulars 7 days. The company shall disclose to its member in the financial statement the full particulars of the investment made. Okay. Sure. Practical question 64. Soft and Secure Lenders Limited has convened a board meeting on 25th October 2022. One of the items of the agenda is to approve the grant of loan of rupees 20 crore to Easygoing Industries Limited for expansion of its business activities. At the board meeting, out of the total of 6 directors of the lending company, 5 directors were present, and except one director, the remaining 4 directors approved the grant of rupees 20 crores to Easygoing Industries Limited. The borrowing company has taken loans from a public financial and also deposits from public. Examine the loan proposed with reference to the provisions. Okay. Further, the lending company has taken a loan from a then prior approval of in the given case, the fact that the borrowing company has taken a loan from public has as well as deposited from are immaterial as well as any transaction of advancing. Okay. In the given case, out of the 5 directors present at the board meeting, only 4 have approved the resolution. Thus, a unanimous resolution has not been passed, and hence Soft and Secure Limited cannot grant loan of rupees 20 crores to Easygoing Industries Limited. Further, if the lending company has taken a term loan from a public financial institution, then prior approval of such public financial institutions shall also be obtained, and there should be no default in repayment of public deposits or interest thereon on part of the lending company. Practical question 65. ASK Housing Finance Company Limited are prepared to give housing loans to the employees of Messrs News Pharmacy Limited, subject to the condition that the loans are granted by Messrs News Pharmacy Limited. Messrs New Pharmacy Limited is not a listed company, and the company will be exceeding the limits prescribed under the Companies Act by providing the guarantees. Advise the company about the legal requirement under the Companies Act to give effect to the above proposal. What would be your answer? Section is applicable to the following transactions. Further, as per section, okay. However, explanation states for the purpose. Okay, from the above, it can be that if a company gives loans or guarantee or security in connection with, thereby by reflecting as mentioned are exceeded or not, the loans guaranteed provided in favor of employees are not to be considered. Thus, Messrs News Pharmacy Limited can give guarantee in connection with the housing loan of its. So from the it can be concluded that if a company gives loans or advances loans or gives guarantee or security in connection with a loan obtained by the employees of the company, then the provisions of section 186 are not applicable to such a transaction. Thereby, while calculating 186 mark 1 also, where a company directly or indirectly gives loans to a person or other body corporate, or the company directly or indirectly gives guarantee or provides security in connection with a loan to any other body corporate or person or where a company directly or indirectly acquires by way of subscription intercorporate investments લે તો જ આ લિમિટ્સ શું કહે એમાં ટાર્ગેટમાં આવી જઈએ. Thereby, while calculating okay, axis or not, the loans guarantees provided in favor of employees are not to be considered. Thus, Messrs. News Pharmacy Limited can give guarantee in connection with the housing loans of its employees obtained from ASK Housing Finance Company Limited, irrespective of the fact that it will be exceeding the limit prescribed under the Companies Act, as the same shall be ignored by calculating the said limits. There would be no change in the answer if instead of guarantee, security has to be provided by the company for the housing loans obtained by the employees of the company. Messrs. News Pharmacy Limited can give security for the housing loans obtained by the employees of the company without worrying about the limits given in the section 186 subsection 2 એટલે housing loan માટે તમારે ગેરંટી કે સિક્યોરિટી કઈ બી આપવી હોય ચાલે કેમ કે એ વસ્તુ 186 માં કવર્ડ નથી. Okay. Practical question 66. Vogue Limited has an authorized capital of rupees 250 lakhs and paid up capital of rupees 200 lakhs. The free reserves are there to the tune of rupees 150 lakhs. The company has advanced a loan of rupees 160 lakhs to the other companies as on 30th November 2018. Now the company proposes to advance an interest-free loan of rupees 60 lakhs to its wholly owned subsidiary, Fashion Limited, while the discussed validity 60% higher of the two limits. So has already borrowed a loan of and the proposed loan of rupees 6 lakh, thereby the aggregate which exceeds the limit as far when a loan is advanced by to its wholly or joint venture. Special resolution is not required to be passed. Thus, in the given case, even though the aggregate of loans already provided and proposed to be provided, that is rupees 220 lakhs, is more than the limit under section 186 or section 2, that is rupees 210 lakh. Special resolution is not required to be passed since Vogue Limited is advancing loan to its wholly owned subsidiary. Further, as per section 186, a loan should be advanced at a rate which is not lower than the prevailing interest rate 13510 of government security closest to the tenor. Thus, section 186 clearly prohibits giving of interest-free loan even if the borrower is a wholly owned subsidiary. Thus, Vogue limit cannot advance an interest-free loan. Interest-free loan नहीं आपको जो है 13510 years ની સિક્યોરિટી તમે એટલા ઇન્ટરેસ્ટ રેટ પર આપો છો તો બરાબર છે પણ ઇન્ટરેસ્ટ તમે નહીં આપી શકો. That's the rule. તમે પેલી કન્ડિશનમાંથી ચાલ્યા જાવ છો WS વોસને આપો છો તો ઉપરની SR વાળી કન્ડિશનમાંથી નીકળી જાવ છો પણ અહીંયા 1 3 5 10 વાળું તો કરવું જ પડશે. Now, practical question 67. Messrs. Keith and King Consultants Private Limited seeks your legal advice. Miss Niece, a relative of a director, is to be appointed as Chief Public Relations Officer on a salary of rupees 65,000 per month. A relative of a director is so appointed as a chief. Okay. Section 188 is applicable to the related parties of directors are being appointed to an office or place of profit in the company. Now, the legal requirements for taking a contract or under section are as follows. Any contract or arrangement covered under section 188 can be entered only after passing a resolution at a board meeting. Thus, circular resolution is not allowed. The agenda of the aforesaid board meeting shall contain all the particulars. If any director is interested in any contract or arrangement with the related party, he shall not be present at the meeting during discussion of the resolution relating to such contract or arrangement. Every contract or arrangement entered into under section 188 shall be referred in the board's report to the shareholders along with the justification for entering into such contract or arrangement. Prior approval of the members by way of ordinary resolution shall also be required in the case the appointment is made to any office or place of profit in the company, its subsidiary company or associate company at a monthly remuneration exceeding rupees 2.5 lakhs. The explanatory statement to be annexed to the notice of a general meeting convened. Any member of the company who is related party shall not vote on the ordinary resolution. Miss Niece is a related party as per section 2 subsection 76 and hence can be appointed as Chief Public Relations Officer if all the remunerations of section 188 as mentioned above are satisfied. However, as her salary does not exceed rupees 2.5 lakh, the requirement under point 5 and 7 are not required to be complied with. 65,000 per month, at a monthly remuneration. Okay, monthly remuneration 2.5 લાખ થી વધારે છે તો પછી 5th અને 7th prior approval of members by way of ordinary resolution and any member shall not vote on the ordinary જે related party માં interested છે તે vote નહીં કરી શકશે. Mr. Wellington, a relative of a director, is to be appointed as Chief Executive Officer on a consolidated salary of rupees 2,60,000 per month. Is a related party and hence can be appointed as Chief if all the requirements under section 188 as mentioned above are satisfied. Okay, 180 પેલું exceeding 2.5 lakhs છે તો પછી ઉપરની conditions કરી દોની. Mr. Nephew, who is a relative of one of the directors, to be appointed as a managing director on a monthly salary of rupees plus other requisites is applicable to the company. Mr. Nephew is a related party and is proposed to be appointed. Since the managing director does not draw anything more than the remuneration to which he is entitled as a director, the office of managing director cannot be said to be an office or place of profit. Thus, the appointment of Mr. Nephew as a managing director does not attract the provisions of Section 188, and so the legal requirements specified under 188 need not be complied. Uh, on a monthly salary plus other perquisites is applicable to other executives of the company. Sucha is as per section, since managing director does not draw anything more than the remuneration to which he is entitled as a director, the office of a managing director cannot be said to an office or place of profit. Thus, the appointment of Mr. Nephew as a managing director does not attract the provisions of section 188. એટલે એમાં એવું કહી છે કે ડિરેક્ટરની જેટલું જેટલી હેસિયત છે તેટલું જે મેનેજિંગ ડિરેક્ટર લે છે બીજા ડિરેક્ટર જેટલું લે તેટલું જ લે છે તે પેલું કયું છે વર્ડ કેન બી ઓફિસ ઓર પ્લેસ ઓફ પ્રોફિટ આ વાળું જે ટર્મ છે ઓફિસ ઓર પ્લેસ ઓફ પ્રોફિટમાં વધારે પડતું રેમ્યુનરેશન નથી લેતો તો એ ચાલે એના માટે પેલું રિલેટેડ પાર્ટી માટે એનું બીજી બધી કન્ડિશન્સ કમ્પ્લાય કરવાની જરૂર નથી. નાઉ 68. Reliable Castings Limited is a subsidiary of Unique Machineries Limited. The board of directors of the respective companies have made the following appointments on a consolidated monthly salary of rupees 2,54,000 with effect from 1/6. Shri Ram Singh, a director of Unique Machineries Limited, as factory manager of Reliable Castings. A director of holding company shall be deemed to be related party. So for reliable casting appointment of Sri Ram, who is the director of its holding company, shall be considered as appointment of a related party to office or place of profit. Thus, reliable charges must comply with the legal requirements of Section 188 as mentioned above. Okay. Sri Rajesh Patel, a director of Reliable Castings as purchase manager of Unique Machineries Limited. Okay, so Pelamacha, director of subsidiary company is not a related party for its holding company. So for Unique Machineries Limited, appointment of Sri Rajesh Patel, who is a director of its subsidiary company, shall not be considered as a related party contract. Hence, the legal as mentioned above not to be complied. એટલે જો હોલ્ડિંગ માટે સબસિડરીનો ડિરેક્ટર રિલેટેડ પાર્ટી નથી. હોલ્ડિંગ માટે સબસિડરીનો ડિરેક્ટર રિલેટેડ પાર્ટી નથી. પછી Sri Sundar, relative of director of Unique Machineries Limited as sales manager of Unique Machineries Limited. Relative of director of Unique Machineries Limited as sales manager of Unique. Okay. Sri Sundar, relative of director of Unique Machineries Limited, is a related party for the company. Hence, the appointment as sales manager shall require compliance. A related party cha. Sri Rakesh, not related to any director of both the companies, as chief accountant of Unique Machineries, but his relative has been appointed as Unique Machineries Limited with effect from one. She is not a related party and thus he can be appointed as chief in accounts without complying with the legal requirements. Thus, she is further provisional do not have any retrospective application. Thus, if Sri Rajesh becomes a related party to the company after his appointment, that will have no effect on his appointment and will not be considered to be in contravention of section 188. But his relative has been appointed as additional director of Unique Machineries Limited with effect from 1/1/2022. એટલે પહેલા તો એ રિલેટેડ પાર્ટી નહીં હતો પણ પછી બને છે પણ રેટ્રોસ્પેક્ટિવ ઇફેક્ટ નહીં આવે પણ જ્યાં સુધી હતો ત્યાં સુધી તો કન્ટિન્યુઅસ રહેશે એમાં. 69. Sweet Tea Limited wants to sell its tea by entering into contract with the following parties. Tea Bros, a partnership firm in which a director of Sweet Tea Limited is a partner. Any contract between a company or any supplier of goods as per related a firm in which a private company in which a director or manager or his relative is a member or director, a public company in which a director or manager is a director and holds along with his relatives more than 2% of its paid up share capital. Thus, in the given case, all three parties are related party to Sweet Tea Company Limited. Therefore, if Sweet wants to enter into the contract with the following legal requirements, 7 point રટવા પડશે. Practical question 70. The board of directors of Messrs ABC Motors Limited made the following appointments at the meeting held on 1st January 2018. Mr. X, a director of its subsidiary company, namely Messrs ABC Foregoings Limited, was appointed as purchase on a consolidated salary of rupees 1 lakh per year with effect from 1st January 2018. As for a director of the holding company is a related party, but Mr. X is the director of ABC, which is a subsidiary of in relation of ABC. Mr. X is not a related party and hence his appointment does not require compliance of with section 188. Mr. Y was appointed as a sales manager on a consolidated rupees with effect from 1st January. Dialect under Jela Chalsa is not a related party at the time of his and thus he can be appointed as sales manager without complying with the legal requirements. Further, the provisions of Section 188 do not have any retrospective application. Thus, if Mr. Y becomes a related party to the company after his appointment due to the appointment of Mr. P as a director of ABC Motors Limited, will have no effect on the continuation of Mr. Y. Mr. P, a relative, does the appointment of Mr. X requires approval? No. Mr. P, a relative of Mr. Y, was appointed as a director of Mrs. ABC Motors Limited on 1st August. Does it affect the continuation of Mr. Y as a sales manager? No. On the continuation of Mr. Y as a sales manager. પહેલા બની ગયો પણ પછી એનો કોઈ રિલેટેડ પાર્ટી અંદર ડિરેક્ટર બન્યો તો પછી અહીં કન્ટિન્યુ એવું નહીં થઈ જાય કે રિલેટેડ પાર્ટીનું પેલું ડિસ્ક્લોઝર બધું કમ્પ્લાય કરવું પડે સો એ ચાલે. Practical question 71. XYZ Limited, an unlisted company with a turnover of rupees 500 crores, entered into a contract of purchasing of raw material from a private company. XYZ Limited appointed Mr. Khurana, director of the company, to act in the deal of the transaction. Mr. Khurana is also a member of that private company. He settled the said transaction. The board meeting this contract was for 60 crores and entered into the contract after few transactions made under the contract. XYZ Limited finds the degradation in the quality of the product supplied in the board meeting. This contract was challenged considering it as a related party transaction and contravention to Section 188, subsection 1. During this period, Mr. Khurana was appointed as director in newly set up PQL Limited. In the light of the given provisions, examine what is the legal position of the contract entered between XYZ. Thus, it is clear that as per contract and therefore, in the present case, the contract is voidable at the option of board or shareholders of XYZ Limited, as the case may be, unless the contract is ratified by the board and the shareholders at a meeting within 3 months from the date on which such contract was entered. Therefore, a contract should be voidable at the option of the board or the, as the case may be, where any contract is entered into by or any other employee without obtaining the consent to the board or approval by an ordinary resolution in the general meeting as required under Section 100, and if it is not ratified by the board or the shareholders, as the case may be, at a meeting within 3 months from the date on which such contract was entered into. Therefore, in the present case, the contract is voidable at the option of board or shareholders. Vice is there any contravention? Comment upon the appointment of me as a director. Okay. Yes, it is evident that the company has contravened the provision of Section 188, subsection 1. Further, as per Section 188, company may proceed for recovery of any loss sustained by it as a result of such contract or arrangement from the director or any other employee who had entered into such contract or arrangement, and if the contract or arrangement is with a related party to any director or is authorized by any other director, the director's consent shall indemnify the company against any loss incurred by it. Thus, Mr. Khurana shall be liable to compensate and indemnify the loss sustained by XYZ Limited. Also, as per Section 188, the defaulting director, that is Mr. Khurana, shall be liable for a penalty of rupees 5 lakhs since XYZ Limited is an unlisted company. As per Section 164, a person shall not be appointed as a director if he has been convicted of offence or delayed. Thus, if convicted, shall be disqualified from being appointed as a director in any company for a period of 5 years. Also, as per Section 167, subsection 1, if Mr. Khurana is convicted, he shall be required to vacate his office of directorship in all the companies in which he is director. Thus, if convicted, Mr. Khurana shall be required to vacate his directorship in XYZ Limited as well as PQL Limited. જો convict થઈ ગયો તો બંનેમાં છોડવું પડશે. The register of contracts or arrangement under Section 189 of the Companies Act is maintained at the registered office of Fortune Limited under the custody of the company secretary. The AGM was held in different place, but in the same town where the registered office is situated. Mrs. Semar, a shareholder of the company, and Mr. Raj, a proxy of shareholder, insisted for producing the said register at the commencement of the AGM for inspection. The company secretary refused to produce stating that being the statutory, it has to be maintained at the registered office only. AGM so every company shall keep one or more register giving separately of all the contract to which 184 subsection 2 in disclosure or section 188 applies. Such register shall be kept at the registered office of the company. It shall remain open for inspection at such office during business hours and copies thereof as required. Further, the said register shall be produced at the commencement of every general meeting. It shall remain open and accessible during the continuance of the meeting to any person having the right to attend the meeting. The members and their appointed proxies are authorized by the Act to inspect such register at the AGM. In the given case, the company secretary refusal to produce the register at the venue of AGM, stating that it being a statutory register, it has to be maintained at the registered office only, is not valid. As per Section 189, the register has to be maintained at the registered office, but it has also to be kept open for inspection during the continuance of the AGM. So both the provisions must be complied with. Hence, the company secretary must have moved the seed register for a day from the register office to the venue of AGM for complying with Section 189. Hence, both Mr. Simmer and Mr. Raj are entitled to inspect the register maintained under Section 189 and the refusal by is invalid. Practical question 73. Accurate Arcs Limited maintains the minutes book of the board meetings in loose leaf system and get them bound in 3 months. Can it do so? As per section 118, every company shall cause to be prepared, signed and kept minutes for proceedings of the board meeting. The meetings minutes shall be maintained in the books kept for that purpose. Further, minutes shall be prepared and signed in such manner as may be prescribed. That minutes have to be maintained in the book. Further, each page of minutes book shall be consecutively numbered. Thus, maintenance of minutes in loose leaf form is not permitted. Loose leaf money चाले book बनाने राखो भाई. 74. Board meetings were held on 24th November 2014 and 15th December 2014. Mr. Rameshwar, who was the chairman of the two board meetings, died on 20th December 2014 without signing the meetings. How should be meetings signed? As per section, the minutes may be signed by the chairperson of the said meeting or the chairperson of next succeeding meeting. The minutes should be prepared and signed within 30 days of the conclusion of the board meeting. In the given case, the minutes of the meeting held on 24/11 should be signed either by the chairperson of the meeting or by the chairperson of the next meeting held on 15/12/2014. Incidentally, the chairperson of both these meetings is Mr. Rameshwar, who has died. The result is that the minutes the board meetings held on 24/11/2014 has remained unsigned. With regards to signing minutes of the board meeting held on, the same can be done by the chairperson of the next succeeding meeting. So the main issue is signing of minutes of board meetings held on 24/11/2014. There is no provision in the law which specifically deals with this situation. Therefore, it is advisable to convene a board meeting and appoint a chairperson who shall be authorized to sign the minutes of the meeting. 24/11/2014 लॉ શું કહે છે કે 30 દિવસની અંદર અંદર થઈ જવું જોઈએ. એક મીટિંગ 24/11 થઈ, એક મીટિંગ 15/12 થઈ. હવે 15/12 એ સાઇન કોણ કરી શકે? કાં તો ચેરપર્સન કરી શકે, કાં તો નેક્સ્ટ મીટિંગનું ચેરપર્સન. હવે આજે આપણે 15/12 વાળી જે મીટિંગ કરી તેનો તો નેક્સ્ટ ચેરપર્સન આવી શકે, પણ આ વાળી મીટિંગમાં 24/11 કરી તેનો તો નેક્સ્ટ બોર્ડ મીટિંગનો ચેરપર્સન બી આપણો મિસ્ટર રામેશ્વર જ હતો, પણ એ મરી ગયો. તો એવું કહે છે કે લોમાં આવું કોઈ છે નહીં, તો પહેલા એવું કહે ઇટ ઇઝ ટુ કન્વીન અ બોર્ડ મીટિંગ એન્ડ અપોઇન્ટ અ ચેરપર્સન હુ શેલ બી ઓથોરાઇઝ ટુ સાઇન ધ મીટિંગ મિનિટ્સ ઓફ ધ મીટિંગ. કે બોર્ડ મીટિંગ કરીને ડિસાઇડ કરી લો કે કોણ સાઇન કરશે. ચાલો પ્રેક્ટિકલ ક્વેશ્ચન 75. 17th board meeting of Jai Entertainment Limited was held at its registered office situated at B17 Industrial Area, Sun City. While discussing the matter of appointment of Mr. Kabil as managing director of the company, certain defamatory remarks were made by Mr. X, one of the directors. The draft minutes submitted by the company secretary also incorporate the incident remarks of Mr. X. The chairman wants to remove those undesirable remarks from the minutes. Can he do so? The minutes of a meeting are a written record of the business conduct decisions and resolutions arrived at the meeting. The minutes of a board meeting are maintained as per the provisions of section 118. As per the section 118, no matter shall be included in the minutes which in the opinion of the chairman of the meeting can be regarded as defamatory, is irrelevant or immaterial, is detrimental to the interest of the company. The chairman shall exercise absolute discretion with regard to the inclusion or non-inclusion of any matter in the minutes on any of the grounds specified above. In the given case, since the remarks made by Mr. X are defamatory in nature, the chairman can exercise his discretion and remove those undesirable remarks from the minutes. Mr. Khabrilal, 76 number question. Mr. Khabrilal is a member of Mrs. Bhola Bhandar Limited and wants to inspect the minutes book of the minutes of the meetings. Mr. is a member of Mr. wants to inspect the minutes book of the minutes of the board. Can I do so? I am authorized to inspect and obtain the copies of the minutes of the general meeting. However, the section doesn't confer any right to inspect the minutes of a board meeting. The company contains no provision which specifically permits or prohibits inspection of the minutes of board meeting by the members. So in that case, the provision of the AOA of the company in this regard shall be followed. If articles specifically confer on the members a right to inspect minutes of board meeting, then the member can do so. However, if the articles prohibit such inspection or if the articles are silent on this matter, then the member shall have no right to inspect the minutes of a board meeting. Thus, in the given case, if the articles of Mrs. Bhola Bhandari Limited give a right to the members to inspect the minutes, the inspection by Mr. Khabrilal cannot be declined. Otherwise, Mr. Khabrilal has no right to make the inspection. Practical question 77. Mr. K is making an arrangement to acquire some stock in trade from BL Limited for consideration of some furniture lying with him. He is a director of JS Limited, which is the holding company of BL Limited. Mr. K is making an arrangement to acquire some stock in trade from BL Limited. Okay, Mr. K stock in trade લેવા માંગે છે BL Limited થી. for consideration of furniture lying with him. He is a director of JS Limited. આ માણસ JS Limited માં director છે, okay, which is the holding company of BL Limited. Okay, એટલે આ holding છે એની. Advising on the basis of the provisions, what will be the position of the arrangement if there is a contravention of the applicable. When a director of a holding company acquires or is to acquire assets for consideration other than cash from the company, provisions of Section 192 are applicable. In the given case, Mr. K, a director of JS Limited, which is the holding company of BL Limited, is making an arrangement to acquire some stock in trade from BL Limited for consideration of some furniture lying with him. This kind of an arrangement clearly falls within the purview of Section 192. Following are the legal requirements to be complied as per Section 192 for making into such arrangement. Prior approvals for such arrangement is taken by ordinary resolution of the company, that is BL Limited in general meeting. Since the arrangement is with the director of holding company, prior approval is also to be obtained by passing an ordinary resolution in general meeting of the holding company. પોતાની કંપનીમાં હોલ્ડિંગમાં બી further the notice for approval of resolution in general meeting issued by the company and the holding company shall include the particulars of the arrangement, the value of the assets, and thus the above mentioned legal requirement must be fulfilled and his holding company JS Limited for entering into proposed non-cash with Mr. K, who is the director of JS Limited. If any arrangement is entered into by a company or is holding in contravention of the provisions, however, the Section 192, the state shall be voidable at the instance of the company. However, the arrangement shall not be voidable if the restitution of any money or the consideration which is the subject matter of the arrangement is no longer possible and the company has been indemnified by any other person for any loss or damage caused to it, or any rights are acquired bona fide for value and without notice of the contravention of the provision of this section by any other person. Apex Limited is an unlisted public company and having 10 directors in its board. At a duly convened meeting at the board of directors of the company held on 14th August 2022, it was proposed to approve entering into contracts or arrangements with E Limited and Q and Associates, a partnership firm. Mr. Y and his spouse hold 2% and 1% shareholding respectively in E Limited. Mrs. Z, spouse of Mr. Z, is a partner in Q and Associates. Mr. Y and Mr. Z are the directors of Apex Limited. The board meeting was attended by 5 directors, including Mr. Y and Mr. Z. All the directors participated in the discussion and voted in favor of the resolution. The contracts were approved. However, Mr. Y and Mr. Z disclosed their respective interests in the contracts at the earlier board meeting held on 25th May 2022. In the light of the above provisions mentioned, whether the board meeting that was held and the transactions therewith are within the provisions of this Act, under what circumstances any arrangement entered into by the company in violation of Section 192 of the companies dealing with non-cash transactions involving directors shall not be held voidable. As per Section 173, subsection 1, the time between the okay. As per Section 184, every director shall disclose concern, must disclose that they were thus Mr. Y and Mr. Z, when they make a general disclosure of interest as per Section 184, some must disclose that they are interested in E Limited and Q Limited associates respectively. Section 1 is applicable where a director is in any way, whether directly or concerned or interested in a contract or arrangement or proposed contract or arrangement entered into or to be entered into with a body corporate, in such a director in association with any other director holds more than 2% shareholding of the or such director, and when section 1 is applicable, the interested must disclose okay. In the given case, Mr. Y holds 2% shareholding. His wife shall not be included in E Limited since it is not more than 2%. Mr. Y is not interested directly as per section 184, and hence no disclosure of interest was required to be made in the board meeting held on 25th May 2020, where the contract was first discussed. Similarly, the provisions related to the disclosure of interest as per are not applicable to Mr. Z, since his wife is a partner in Q and Associates and not himself. Therefore, no disclosure as per section 184 subsection 2 was necessary on the part of Mr. Z. But as per section 2 subsection 6, a related party with reference to a company inter means a firm in which a director, manager or his relative is a partner, a public company in which a director or manager is a director and holds along with his relatives more than 2% of his share capital. Thus, applying the above definition of it is clear that Apex Limited and E Limited, as well as Apex Limited and Q and Associates, are related within the meaning of two of the Act. We have assumed that the contract or arrangement entered between Apex Limited and E Limited, as well as Apex Limited and Q and Associates, is of the nature of contracts covered in Section 188. Therefore, since a contract is being entered between related parties as per Section 188, it must be approved by a board resolution passed at a board meeting only. Further, Section 188 read with prescribed rules states that if any director is interested in any contact or arrangement with a related party, such director shall not be present at the meeting during discussion on the state resolution. So the board meeting convened for the state contacts, that is on 25/5/2022 as well as on 14th August 2000, cannot be attended by the interested directors Mr. Y and Mr. Z as per Section 188 read with the prescribed rules. Now, as per Section 174, the quorum for the board meeting shall be one third of the total strength of the directors. Any fraction shall be rounded off as one or two directors, whichever is higher. In the given case, the quorum for the meeting held on 14th August shall be 4. That is one third of 10th, that is 3.3. The seed meeting was attended with five directors, including Mr. Y and Mr. Z, who are not allowed to enter the seed meeting. Thus, the meeting can be said to be attended by only three directors, and therefore the quorum is not present in the meeting. So, the meeting held on 14th August 2000 as well as the result passed that shall be considered as invalid. Circumstances under which any arrangements entered into by the contract in violation of Section 192 shall be held voidable are as follows. The restitution of any money or other consideration which is the subject matter of the arrangement is no longer possible and the company has been indemnified by any person or loss damage caused to it, or any rights are acquired bona fide for value and without notice of the contravention of the provision of the section by any other provisions.